This case dives straight into a complicated legal battle, but underneath it all is a simple question. Who actually owes the money? Two men, a dissolved business, and a debt that's been sitting untouched for years suddenly collide in court. One side says a judgment still stands. The other claims a company no longer exists, and therefore neither should the obligation. But here's where it gets intense. The defendant openly admits he may have waited out the system, believing the debt would disappear over time. Now, the court must decide whether this is a clever legal loophole or a clear attempt to avoid responsibility. And the biggest twist, even if the debt can't be collected easily, the court might still bring it back to life. So ask yourself, can a debt ever truly disappear, or is it just waiting to resurface?
We can continue with
I don't think we've gotten to that yet. I have a lot of questions. And actually, my question is to you. How did you perfect service on my 86-year-old mother? Because I have never in my life lived at my mother's house. So if you served me at my mother's house, then how did you even get that information that I live at my mother's house? I don't understand. How can somebody be served? In my opinion, I should be in the exact same spot as Mr. Gagrin. Every person involved in Martini's Red Room knew that I lived in Costa Rica. I waited until this thing expired to sell my house that I had rented until after this expired. And that they had 7 years to clear that up. Secondly, my next question is, how in the world are you representing Martini's when Martini's literally abandoned the corporation in 2011 and was administratively dissolved December 31st of 2015? There is no Martini's, and there was no paperwork filed saying that Mr. Aducci was taking over all of the assets or potential assets of Martini's. So first off, I was not served. Secondly, there is no Martini's. And thirdly, Mr. Gagrin and I were not actually, we were owners of the Red Room, and we were guarantors on these loans. We were not the original loan, I guess you would say, Red Room. That the agreement was between Red Room and Martini's. Both of those entities are gone. We were guarantors on the loan, and the loan expired with absolutely nobody even attempting to collect on the debt. So this is the craziest part about it. 7 years went by. I owned a house for 4 of those years and a car in the state of Georgia. Now none of that is the case. And I think Mr. Kaplan probably received a letter from a law firm that represents me. I am on Social Security disability. I am protected by the American for Disabilities Act, and I have several other protections that absolutely, I believe if we went to court and I hired an attorney, or if I even did this on my own, took care of this on my own, that a jury would definitely find that Mr. Gagrin and I are not liable for this anymore. Whether Mr. Ducci thinks he is the person that should get this money, I don't believe he is. I believe it's Martini's Inc. And there is no Martini's Inc. Martini's Inc. is dead. It was forfeited. So that is my argument to this whole thing. And next to that, there is no way in the world that if I sit here and gave you my banking information, that Mr. Kaplan would be able to collect anyway, because it's Social Security disability. And I'm happy to share that information. And that letter that was sent to Mr. Kaplan, probably 3 weeks ago, explained that. Did you get that letter, Mr. Kaplan? Hello?
Your Honor, I'm not sure what I'm supposed to do.
This is where the tension really starts to build. The defendant argues that he was never properly served, claiming legal notice went to his elderly mother instead of him, even though he was living abroad. That's a serious claim, because proper service is critical to due process. But the opposing attorney flips the narrative completely. Instead of a victim of improper service, he paints the defendant as someone who knew about the judgment and intentionally waited for it to expire before selling assets. Now, the judge steps in and clarifies something important. This hearing isn't about collecting the money. It's about reviving the judgment itself. That means even if the defendant currently can't pay, the debt can still legally exist and be enforced later. So here's a big question. Is this a case of someone being wrongfully pursued, or someone who tried to outsmart the system?
Do not believe that is the case, ma'am. And I really, that's why we need, if you want to keep this up, then let's just take it to court. Because
We
I am
we are in court.
100% willing.
This is court.
This is court.
Well, I
Jerome,
understand, ma'am, but we
Jerome.
need a court by jury, and that is what we are guaranteed the right to. Because
Well,
I need to.
you had that in the initial action. You had the opportunity to have a jury in the initial action. Unfortunately, because of the legal posture of the case, it was decided by summary judgment, which meant that the defense put up no evidence that would have been something that could have been considered by a jury.
Yes, ma'am.
The evidence that was presented on paper basically said that the judge made the decision to grant the judgment because there was no defense against the judgment being owed, number one. Number two, with you being the guarantor on a loan, it's just like when you go with somebody and they say, hey, can you co-sign me buying a car? Horror stories I've heard ad nauseum. Well, if they don't pay for that car note, then the person who co-signed is, in fact, the person that the company is going to come after, and the person, in fact, who owes the money. Now, it does not speak well of you that you basically have admitted to trying to avoid paying a judgment that you owed for a business deal, because what you're saying is, well, it was a business. Martini's is a business. It's not here anymore. So we're deciding not to pay them because there's no actual person. When Martini's didn't, Martini's may have been the business that collected the money, but some person, that money was owed to some individual. And so what you're saying is, well, I've gotten away scot-free. I managed to live the 7 years without them collecting. And now I'm an expat in Costa Rica and y'all can't get me. That doesn't mean they're not entitled to the judgment. It just means that you've, to this point, successfully avoided the obligation of paying the judgment.
Okay, one other
somewhat
aspect.
Dishonorable, actually.
Well, ma'am, it's not dishonorable, and let me explain why. I sold my share of the Red Room to Mr. Gagrin. And over the next year and a half, the Red Room business started going down, and he was not able to make the payments. But he guaranteed that I would be exempt from this loan. So yes, I did not feel obligated to pay this loan. So I still haven't heard anything about how in the world service was perfected, because ma'am,
Mr. Kaplan, you said you perfected service by publication. Is that correct?
That is correct. And we knew that
right.
he was in Costa Rica because he sent correspondence saying, I'm in Costa Rica. Here's how you can contact me. And
Right.
so we knew he was there. So I filed the statute because he was in Costa Rica. The court entered in order and he was served by publication. And, to add on to what you said, Your Honor, I mean, my client sold his business. They bought a business without paying for it. Whether it succeeded or failed after that is on them. Whether Mr. Gagrin said he was guaranteeing Mr. Stooksbury's payments is between them.
I'll only point out that I don't think Mr. Gagrin said that, at least not today.
Nope, he didn't say anything today.
That's correct.
I like to make a clear record. All right. So the service was an issue. I wrote down everything you said, Mr.
At this point, the judge carefully addresses every argument one by one, and this is where things become crystal clear legally. First, even if the company Martinis no longer exists, that doesn't automatically erase a debt. Why? Because the defendant was a personal guarantor on the loan. And in legal terms, that's huge. A guarantor is essentially saying, if the business doesn't pay, I will. Second, any private agreement between the two defendants, like one promising to take full responsibility, doesn't override the court's judgment unless it's formally recognized. And finally, the judge explains a key distinction, collectability versus validity. Just because a debt is hard to collect, especially from someone living overseas, doesn't mean it's no longer valid. So think about it. Should personal guarantees follow someone forever, even after businesses collapse?
Release and the obligation of Mr. Gagarin to completely pay the entire judgment. So that's something between the two of you. That is something that you all will have to work out. As such, the court still believes that the judgment is owed jointly and severally by the two of you. And with you being an expat, it may not be a judgment that is collectible, but it doesn't mean that it can't be the judgment can't be revived. So those are two different things.
Ma'am, the only reason I am addressing this at all is because there are a lot of people going to jail that are in my situation for debts, whether they owe them or not. And the courts saying that we did not show up because we never received notification. And I am in a situation to where that is possible. The notice that came to me, I just received on Thursday. And that's been 2 months since it was sent to me, except for by email. But I don't want to be in a situation where I come back to the U.S. to visit my family and I've got some warrant out for my arrest because Mr. Kaplan filed a hearing and I knew nothing about it.
Well, I got that. The only way that would happen on a civil case is if you had failed to participate in post-judgment discovery and there had been a long period of your not participating after being served. However, in this case, I don't have the ability to do that because you're outside the country. You haven't been served with post-judgment discovery, and I cannot order you as a part of a discovery dispute to appear before the court and complete the discovery, which is the only way in a civil case that there may be some. So what? It's civil. It is not criminal, and I don't have that power to exercise against you. Essentially, what this is that it revives the judgment, meaning it tells the court tells everyone that this judgment is once again collectible, and you can use whatever efforts under Georgia law to collect the judgment. It doesn't mean that I get to put anybody in jail.
Okay. Then in that case, we're just wasting the court's time, really. The problem that I have is if Mr. Kaplan says that he's going to serve my 86-year-old mother this paperwork for whatever he plans to do to try to figure out where all of my billions of dollars are, then, that's the problem that I have. I do not want to come home, visit my family, and have that hanging over my head. So you're telling me that is not possible, or that is not going to happen?
I'm telling you that I cannot jail you.
Right.
And there will be no warrant waiting for you when you come into the country because you have not been served discovery that you've not responded to. That is a process. Number one, that would be the only way that a warrant would be waiting for you. But the attempts to collect, I don't get involved in the attempts to collect on a judgment. Georgia law is very expressive on how you can collect on a judgment in the state of Georgia. Once the
Right.
judgment is revived and a 5A has been issued, then there are steps that can be taken under statute to collect the judgment. So that's what that then again becomes between you and Mr. Kaplan, how he wants to collect, but has nothing to do with me. Aside from reviving the judgment and making the judgment once again legally viable.
Okay. Well, I'm sure Mr. Kaplan understands the certain things that need to be made clear in this situation, and he's already received. Mr. Kaplan, did you say that you have received the letter from Helps Law Firm?
Okay. I'm not in my office in the moment. I don't know. Your Honor, I don't know what he's talking about, to be honest with you. I may have initially tried to serve him in the United States at a last known address. Once he gave word that he was in Costa Rica, we've proceeded in accordance with, that. I've been doing this a long time, Your Honor. If he doesn't like this hanging over his head, I'm happy to talk to him. Otherwise, I don't know what to say.
I as long as I'm not gonna have a warrant hanging out over my head, it's not a concern for me. This should have been taken care of when Mr. Ducci and I in 2017, when I made him an offer and he accepted, but he never showed up.
No, there was no acceptance of that offer.
Okay.
You accepted it verbally.
Okay, whatever negotiations went on have nothing to do with me.
Okay.
I am strictly here because there is a judgment. The time has run on that judgment. The law allows the debtor to come and seek to have the judgment revived. That is all I'm doing. So any negotiations that take place around how this can be paid, or how it should be paid, or how it can be collected or should be collected, I'm not being insensitive, but I really don't care because those don't involve me.
Well, ma'am, you have the exact same stance on that as I do on this so-called debt.
I got you. But I mean, I spend a lot of my time teaching business people to think in ways that are to think, I guess, more like a lawyer. And in the sense, I think a lot of business people think of things in ways that aren't legal. And I don't mean illegal. I mean, they don't follow a legal course. And so if you have a business that buys another business and the money is owed, doesn't mean that just because the business goes away or you decide not to pay it or you wait it out, that the money won't be collectible at some point. And so just to assume, because I have a lot of people on my calendar who have credit card debt, and they think that because that credit card debt expired or was 10 years ago or 15 years ago, and they weren't even the person who was, they're not even the same person anymore, as some people have said. They think that goes away, but it just really doesn't. And so you deal with it once it's revived, however y'all want to deal with it, but it doesn't mean I cannot, under the statute, revive the judgment.
Right. And those very people that have that credit card debt that is outstanding are in a similar, some of them are in a similar position as I am, and they take the risk, from what I understand, of somebody saying that they served them, but they were never served. And then there is a warrant out for their arrest because they never addressed the court when they didn't know anything about it. That has happened quite a bit.
Okay.
Your Honor,
that's my only concern.
I got you, Mr. Stooksbury.
Okay.
Anyone else have anything else at this time?
Yes, Your Honor. One more thing. It is kind of a red letter day for me, as Mr. Gagarin and his attorney are both present. I was wondering if it's possible, since Mr. Gagarin, we can hear him in the house, we can see his car, and he's got this camera there, that, the next thing we're going to do is move for, notice by publication, which is a risk to him because he may not realize it's being published and he may not be able to get his day in court. My question for you is, since we have both of them here, and Mr. Calamaro doesn't have authority, but his client is right here with him, if we could put him in a breakout room and see if they will acknowledge service on the next writ of scary fascists that you enter for a court date, so that we can just get on with this and move forward.
So this is what I am hearing. Mr. Kaplan is saying that because Mr. Gagarin, his words, not mine, is actively avoiding service of process, he wants to seek a service by publication in this case. Mr. Calamaro? They're not required to make a statement, but I'm giving you the opportunity to do so.
Yeah, I mean, so a couple of things. I mean, I might point out that I don't even believe you can serve this petition by private process server. I'm fairly certain it has to be served by the sheriff.
We will.
Okay.
So I mean, we're getting a read on things, and I can tell you he's got a camera up. We'll have somebody testify whether they're qualified to serve or not. They're somebody that was there and observed that they went there one day and it wasn't there. Then the next time it was, that he has it, that he's in there, that his car's there. He's avoiding service. So whether a sheriff goes out the next time or not, and he hears a body inside and sees the car in the driveway, we're going to request the judge issue an order, and we can serve by publication when he's avoiding service. So we can do this, or we can do this for the next 5 years. It doesn't matter to me. It just seems silly.
Well, it's silly to you because you're representing somebody that says that they are owed this money.
I got it, Mr. Stooksbury, but hold on a second. This is sort of pointed towards Mr. Gagarin at this point.
Yeah.
Mm-hmm.
So at this point,
I do not have authority to do it. I'll say that.
I got you, Mr. Calamaro. So at this point, Mr. Kaplan, if you will get me an order, you have my new staff attorney's email, Ms. Powell?
Yes, ma'am.
All right. So if you'll send Ms. Powell an order, then we'll go ahead and sign off on that. And whether you serve by publication or not, it's entirely up to you. I'll consider whatever orders I receive in this case. But now that we have smoothed the road, at least to having all parties present and heard, then, I will be here by video court if necessary the next time. Is there anything further at this time?
No,
no, Your Honor. Appreciate your time.
Thank you.
No problem.
And
all right.
I would like for contact information for Mr. Gagarin's attorney. I'm not sure that I'm going to even bother with this, but it would be worth.
I can put you all in a breakout room. That's no problem. Mr. Calamaro, do you have an opposition to that?
No, I'm thinking my way through the potential for a conflict.
Yeah,
yes,
that's
I understand that. That's what I was going to discuss with you.
Okay.
So I don't know if he's seeking representation or if he's wanting to talk
I
to
don't
you about...
know. I'd rather not.
In the end, the judge makes a clear and measured decision. The judgment will be revived. That means the debt is officially back on the table and can be pursued under the law. However, she also reassures the defendant of something critical. This is a civil matter, not criminal, meaning there's no arrest warrant waiting for him just because of the debt. That distinction alone changes the entire emotional weight of the case. But the story doesn't end here. The next battle will be about collection efforts, potential negotiations, and whether the other party can actually recover the money, especially with one defendant living abroad. This case highlights a powerful lesson. Business deals don't just disappear when companies fail. Legal obligations can follow you for years, even across borders. Now we want to hear from you. Do you think the court made the right decision, or should the debt have been considered expired for good? If you found this case as fascinating as we did, make sure to like, share your thoughts in the comments, and subscribe for more intense courtroom breakdowns.